Ever really thought about what it means to own a share of stock? I mean, in a world where literally millions of people can own a tiny slice of the same company, it begs a pretty huge question. Who's actually running the show? We're about to unpack the legal framework that decides who really calls the shots.
So let's just think about that for a second. You buy a share of stock, right? You technically own a piece of that company. But does that mean you can just waltz into the CEO's office and start telling people what to do? Well, the answer is complicated. And that puzzle is exactly what corporate law is built to solve.
See, at the very heart of any modern corporation, there's this fundamental split. On one side, you've got the owners. We call them shareholders, the people who put up the money. And on the other side, you have the managers, the directors and officers, the pros who are hired to run the day-to-day operations. This idea is known as the separation of ownership and control, and it's the foundation for pretty much every big company you can name.
But that separation, that very structure, creates this natural tension, a kind of built-in dilemma for the folks in charge, because when the people running the company aren't the same people who own it, well, their interests might not always be perfectly aligned. So how does this conflict actually happen? It all starts with that split between owners and managers. The owners can't run the company themselves, so they have to delegate their authority. But the second they hand over that power, they open the door to a huge risk, the risk that the managers might start looking out for their own interests, not the company's. And there's a legal term for this, of course. It's called an agency conflict. Just think of it like this. The shareholders are the principals, and the managers they hire are their agents. The conflict is what happens when the agents start going off script, chasing their own goals instead of the ones the principals hired them for.
So what does this look like in the real world? Well, imagine a manager pushing for some risky short-term project just to juice their annual bonus, even if it could hurt the company down the line. Or maybe they avoid making a tough but necessary decision because they're worried about their own career. That is the exact problem that corporate law tries to head off at the pass. So, how does the legal system wrestle with this problem? It puts in place a really powerful set of rules called fiduciary duties. And these duties create a super clear framework for holding the people in charge accountable. A fiduciary duty is one of the highest standards of care you can find anywhere in the law. It's basically a legally enforced promise that directors and officers will always put the company's interests first. You could even say it's a legal requirement to be trustworthy. These duties are the guardrails for every single decision a corporate leader makes.
And these duties really boil down to three main pillars. You've got the duty of care, which is all about being diligent. Then there's the duty of loyalty, which is about putting the company first. And finally, the duty of obedience, which is just about playing by the rules. Let's break each one down.
Okay, first step, the duty of care. Now, this doesn't mean directors have to be geniuses or that they can never make a mistake. It just means they have to be careful. The legal standard basically asks, did they behave like a reasonable, sensible person would in the same situation? In the real world, that means doing your homework, looking at the data, and if you don't know something, you bring in an expert who does. Simple as that. Next is the duty of loyalty, and this one is a biggie. The idea is simple, but it is incredibly powerful. The company's interests always come before your own. No exceptions. So if a director happens to find an amazing business opportunity, they are legally required to offer it to the company first before even thinking about taking it for themselves. It's the ultimate firewall against self-dealing. And finally, we have the duty of obedience. This one is the most straightforward of the three. It just means that the company's leaders have to follow the law. But it's not just about avoiding crime. It also means following the company's own internal rule book, its bylaws and policies. You can't just make things up as you go. So you might be thinking, with all these intense duties and the constant threat of being sued, who on earth would ever want to be a director? I mean, if every bad decision could lead to a lawsuit, no one would ever take a risk, and business is all about taking calculated risks. Well, that's where this crucial other half of the equation comes in. It's called the business judgment rule. And what it means essentially is that courts won't second-guess a business decision just because it ended up losing money. As long as the directors made an informed decision in good faith, the law assumes they did their job correctly. And here is the key takeaway. The rule protects the decision-making process, not the final outcome. So why is this rule so important? Well, for one, it gives leaders the breathing room to take reasonable risks, the kinds of risks that lead to big innovations and growth, without being terrified of failing. It also keeps judges, who are legal experts, not business experts, out of the boardroom.
And ultimately, it lets companies move fast and be decisive when they need to be.
But let's be crystal clear about this. This rule is a shield. It is not a get-out-of-jail-free card. It protects honest mistakes made in good faith. It offers zero protection for fraud, illegal acts, or just plain gross negligence. And if a director was self-dealing or had a conflict of interest, that business judgment rule shield just vanishes. Poof.
So when you put all these pieces together, you've got the duties holding managers accountable on one hand and the shield giving them the freedom to lead on the other. You start to see this system that's designed to manage a really fundamental tension. And that is the whole game right there. It's this delicate balance. The fiduciary duties create accountability, making sure managers answer to the owners. But the business judgment rule provides autonomy, giving those same managers the freedom to lead, to innovate, and to take the risks necessary to make a business successful. It's a constant push and pull between keeping power in check and empowering leaders to actually lead.
But here's the thing. This entire framework, it's old. It was built for a completely different time. So in our world of activist investors, 24/7 news cycles, and global markets that move at the speed of light, the big question we have to ask is this. Does this old system still strike the right balance between accountability and autonomy? Or is it maybe time for an update?